$100,000. I mean, just let that number sink in for a second. It's a massive, frankly unprecedented figure. And until literally just today, it was at the absolute center of a fierce legal battle over the future of the American workforce. A major U.S. federal court ruling has just struck down a policy that would have attached this exact astronomical price tag to a single U.S. work visa. Welcome to This Explainer. I am so glad you're joining us today because, well, we have some major breaking news to unpack. We're looking at a really pivotal July 26, 2026 appeals court decision that officially rejected a monumental fee hike on U.S. work visas. So let's just dive right into this and see exactly how we got here, what the courts decided, and what this whole shebang means for the future of global talent in the United States. All right, Section 1. The $100,000 visa verdict. Appeals court rejects proposed fee. This whole situation unfolded remarkably fast. Let's trace the timeline here. So, back in September 2025, the Trump administration announced this new policy. And the market reaction? It was pretty much immediate. By mid-February of 2026, demand for new visas had absolutely plummeted. Fast forward to June 8, 2026, and a lower court officially struck down the fee. The administration, of course, attempted to revive it, but that brings us to today. July 26, 2026. The first U.S. Circuit Court of Appeals in Boston has officially declined to put the lower court's verdict on hold. They effectively shut down the revival of that $100,000 charge on new H-1B applications.
Moving to Section 2. H-1B visas explained. Who gets them and why?
To really grasp why this legal battle was so high stakes, we kind of need to step back for a second. The H-1B visa is designed specifically for highly skilled foreign workers. The core purpose of this program is to let U.S. employers hire international talent for specialty occupations, when they're struggling to find qualified American employees to fill those roles. These visas are granted by U.S. Citizenship and Immigration Services, or USCIS, and successful applicants usually get a stay valid for about 3 to 6 years. We're talking about critical roles here: engineering, technology, medicine, higher education.
Now, getting one of these, it's highly competitive because of a very strict annual cap. The program offers exactly 65,000 standard visas per year, period. Then there's an additional 20,000 visas reserved strictly for applicants who hold advanced degrees from U.S. institutions. So, to put that into perspective, out of all the companies in the U.S. looking to hire global talent, there are only 85,000 spots available each year. It is a highly coveted resource.
Which brings us to Section 3, the proposed fee hike, a monumental financial shift.
Okay, to really understand the conflict, we have to look at the staggering financial shift that triggered it. Historically, employers sponsoring H-1B workers generally paid between $2,000 and $5,000 in government filing fees. But the proposed policy? It sought to skyrocket that cost to an incredible $100,000 per new application. Think about that for a second. For a business trying to bring over a specialized engineer or a medical researcher, that is a 20 to 50 times increase in upfront government fees. It completely changed the financial calculus of hiring foreign talent.
Next up is Section 4, the legal battle. Two competing arguments.
You hike a fee by 50 times, you're absolutely going to end up in court. And this clash was driven by two totally distinct perspectives. The Trump administration argued this steep hike was absolutely necessary to protect the domestic workforce. They argued the H-1B program was being deliberately exploited by some companies to replace American workers with lower-paid, lower-skilled labor, and this fee was meant to heavily discourage that practice. On the flip side, a coalition of 20 Democratic states filed a lawsuit arguing the exact opposite. They said the fee was essentially an unlawful tax, a massive case of administrative overreach, and that it would ultimately cripple vital U.S. industries that rely on this specialized talent. So what did the courts actually say? Well, in his initial June 8th ruling, U.S. District Court Judge Leo Sorokin stated clearly, and I quote, "The court finds that the policy imposes a tax on H-1B petitions without the requisite delegation by Congress." Basically, in the eyes of the court, this wasn't just a simple fee adjustment, it was a newly imposed tax. And under our system, the executive branch just can't invent a tax of this magnitude without Congress explicitly giving them the authority to do it.
Judge Sorokin concluded that by bypassing Congress to levy this massive charge, the executive branch actually exceeded its authority and directly violated the Administrative Procedure Act. If you aren't familiar, that's the fundamental federal statute that governs the exact process by which federal agencies are allowed to develop and issue regulations. You simply can't bypass the established rulemaking process, especially when levying what the court deemed an unauthorized tax. And today, the Boston Appeals Court stood right by that interpretation, officially refusing to revive the fee.
Finally, Section 5. Who is affected? The real-world impact.
You know, it's really remarkable how powerfully just the announcement of a policy can shift an entire market. Technically, according to the mechanics of the policy, the $100,000 fee wouldn't have even applied to foreign nationals already in the U.S. on student visas, and those students make up a huge share of new H-1B recipients. But despite that exemption, the chilling effect was immediate. Like we saw on the timeline, just announcing it in September 2025 made demand plummet. Court filings revealed that by mid-February of 2026, USCIS received very, very few payments under the new structure. Employers essentially just paused or totally abandoned their international hiring plans.
With the fee officially struck down, a lot of state leaders are celebrating today. Massachusetts Attorney General Andrea Joy Campbell released a statement calling it a major victory. She highlighted why this matters so much, stating that striking down the fee protects the program as a tool to address severe labor shortages, specifically pointing to vital industries like education, healthcare, and medical research. For states like Massachusetts, which is just packed with world-class universities and research hospitals, keeping the cost of hiring international faculty and researchers at that original $2,000 to $5,000 mark is seen as absolutely critical.
So this brings us to a major turning point. With this massive financial barrier officially removed by the Federal Appeals Court today, the doors remain open for highly skilled foreign workers under the traditional fee structure. But, the underlying debate, how we balance protecting domestic workers while still attracting specialized global talent, that is far from over. So I want to leave you with this question to chew on. How will the rejection of this $100,000 fee shape the future of global tech and healthcare talent in the U.S.? Will it secure America's competitive edge, or will it just reignite future attempts to overhaul the immigration system? It's a fascinating landscape, and we will definitely keep watching it. Thanks so much for joining me for this explainer, and keep learning.